This conference will now be recorded.
Thank you, Casey. Thank you, Kirsten, for setting this up. We're going to get started so we can get through the presentation and take as many and hopefully all the questions we can. Thank you for joining us today. We're going to cover the Fair Labor Standards Act as it stands today. So I always start out with the slide, and this slide is nice to print out and hang up. It's the top 10 legal mistakes made by supervisors unintentionally, and this is where we always get tripped up on the Fair Labor Standards Act. One, it's mishandling employee complaint issues when people talk to you, failing to apply the policies and procedures, failure to give constant feedback. And the one that's really hard to keep up with, and why we're doing these webinars, is the failing to understand the ever-changing wage and hour laws. I'm presenting this as the law stands today. As we move forward in 2019, the Wage and Hour Division went back to the drawing board after they tried to increase the exempt minimum to $47,000. There was a lot of negative feedback on it. It went into the court system and was stalled. However, they are going to update it in 2019. The exempt minimum, the federal one, will increase, and we're not sure to what threshold yet. And so I will keep you guys, I'll give Rebecca all the updates I can as that comes through, as I believe this spring they'll come out with a revised law and revised minimums. So we'll start now with, we're going to go over the Fair Labor Standards Act, the minimum wage, the exemptions in which an exempt salaried person can fall under, compensatory time, and this one gets, it's different for public versus private employees. And we'll also look at the Wage Theft Prevention Act, which is an extension in New York State of the Fair Labor Standards Act. So the Fair Labor Standards Act, or the FLSA, is also referred to as the Wage and Hour Law, and it regulates your employee status, hourly versus salaried, child labor, minimum wage, overtime pay, and record keeping, which is 6 years after the termination of an employee. It also helps distinguish between an employee and an independent contractor. And this is where most, if not all, of the issues come into play in the Fair Labor Standards Act, where employers will inappropriately classify someone as an independent contractor. So under the FLSA, an employer has no obligations to pay overtime or the exempt minimum salary. However, inappropriately classifying someone as an independent contractor is usually where we get into trouble. To be an independent contractor, the person has to be hired, and the independent contractor controls their own time, has their own resources and materials, and they're basically given the project and they can just run with it. There's no oversight other than meeting project deadlines and end dates. There's no oversight by the employer, and there's a set fee in a contract. So this gets a little sticky sometimes, so we highly recommend, if you're going to hire someone as an independent contractor, you actually speak to legal counsel. So the FLSA exemptions have to be exempt under the Fair Labor Standards Act. You have to meet 3 requirements. First, there's the minimum salary that's set by the federal government, and we'll also talk about how New York State is higher than the federal government. There's a chart in here, and I will show that as we get there. I will show that to you. You have to be paid on a salary basis without improper deductions. So if someone is out sick for a day or half a day, you cannot deduct from their salary. And they have to perform the exempt duties according to the regulations. So currently, exempt employees are exempt from overtime, and the federal minimum is $455 per week, which is $23,600 a year. In New York State, this is much higher. It's almost double. It's $832 per week, which is $43,264 for the year. This cannot be prorated for part-time employees. In order to be, the first test you have to meet is the salary test, and they have to make $832 per week, regardless of hours worked. So that's also a tough one with the new conversion and this New York State being so high. We've had to convert people to non-exempt who want to work part-time, even though their duties are exempt. So this is the new chart for New York State. It goes through December 31st of 2020 for upstate New York. Just starting as of January 1st, the exempt minimum is $832 per week, and the hourly minimum is $11.10. And by 2020, on every December 31st, it's going to go up to $937.50 per week, which is $48,750 per year. So next year it'll go up 6%, and the year after that, I believe it's another 6%. So it's really making large jumps every year in the exempt minimum realm. We are waiting to see what the federal is going to do. I'm assuming it will not go as high as New York is right now, but we're going to watch for that. And whichever exempt minimum is higher is the one the employee has to be paid. It's whatever is advantageous to the employee. So for now, it's $832 a week, not to be prorated for part-time. The exemption tests are also set on a primary duty, and it's the most important duty, and that is performed in the work. So if you have a job description and you have percent times, you always want to make sure that the most important primary duty that has to be fulfilled is first and is probably weighted with more time. It includes the exercise of discretion and independent judgment in matters of significance. So it's about making decisions and how much control someone has over doing that, and about taking risk. And the matters of significance refers to the level of importance or consequence of the work performed. So the first test under the FLSA, is the executive exemption. Not many people fall under here other than managers, directors. They have to manage an enterprise, department, or subdivision, and they have to direct and be responsible for the work of at least 2 full-time equivalent employees. And this could be 4 part-time employees or 1 full-time, 2 part-time. However you can get to the 2 or more full-time equivalent employees, that's fine. They have to have the authority to hire and fire and make salary decisions for their employees, and they have the authority to affect promotion decisions. This is the most widely used exemption, and sometimes this is where a lot of the FLSA mistakes are made, is the administrative exemption. An employee must have a primary duty involving performance of office and non-manual work directly related to the management or general business operations, and it must include the exercise of discretion and independent judgment with matters of significance, meaning the employee must be able to make decisions, they must be able to basically take risks, and have the authority to make decisions without sort of checking in on a daily basis with someone. The next most popular exemption is a professional exemption, and there's 2 parts to this. There's the learned professional, which under the professional exemption, you only have to meet the 455, and that includes New York State. So the higher exempt minimum for New York State of $832 only applies to the executive, the administrative, and we apply it to the computer exemption as well. But the learned professional only has to meet the 455 currently. I think this will change in 2019. They have to have a primary duty that requires advanced knowledge in a field of science or learning and is acquired by prolonged instruction. The work is intellectual in nature and requires exercise of discretion and judgment. This means an advanced degree. How it's typically applied is you must have an advanced degree to be in that field. Like an engineer requires a master's degree, a doctor, a lawyer. It's not something you can learn by being on the job for 20, 25 years. The advanced degree is required to do the job. The second part of the professional exemption, the other one, is you can be a creative professional. You meet the minimum salary, and again, this is $455, and have a primary duty of performing work that requires invention, imagination, originality, and talent. And it has to be in a recognized field of creative or artistic development. One of the examples we use, and it's tough, is a photographer. A general everyday photographer would not fit here, but a photographer for like National Geographic, where they have to go out and get those really beautiful shots of nature or people, that would be an exempt creative professional, and that's in the recognized field. A graphic designer can also fall under this, and it's a graphic designer who is just told, I need this design, and they go out and create it themselves. They're not given the direction of, you need to use this color or these specs or anything like that. They really go out and create that design themselves. So this is a very difficult exemption to meet, but it is out there for people. Excuse me. The next one, where there's a lot of issues also, is the computer employees exemption. There's the minimum salary of $455 or $27.63 per hour. However, we apply the 832 here as well because most people will not meet this exemption that work in the computer field. The primary duty has to be the application of systems analysis techniques, including consulting with users to determine hardware, software, or system functional specifications. This does not mean someone like an IT support person or your desktop support person. They do not fall under this exemption. They are very clear in the regulations that IT support, desktop support is non-exempt and must be paid for by the hour. This is someone like a systems administrator who's running servers and is affecting the use of computers, or maybe a manager who they determine the hardware, software that people can have on their computers. It's also the design, development, documentation, and modification of computer systems or programs. So a lot of coding and programming without be given like the specs, like you need to code this way or something like that. Design, documentation, testing, creation of computer programs related to machine operating systems, or a combination of those. So this one also is very, very difficult to have exemptions under. A lot of people make mistakes and exempt their IT support staff, and that's the one place they're very specific where they do not fall under this exemption and they must be paid by the hour. There's a highly compensated exemption. They must make a salary of $100,000 or more and perform one of the duties in any of the exempt, administrative, executive, or professional exemption salary tests. Most people making an hourly wage will not meet this exemption. So this one is very difficult to meet. They are talking about raising the $100,000 to $110,000. That is still in the courts as well. And in 2019, we should get some of those answers. This is very, very, very important. Volunteering your time. You cannot, under any circumstances, volunteer your time back to your employer if you are already paid to do that job. So, for example, if on a weekend you're hosting an event and your employer asks you to come in to, maybe do a special reading or a special series on the library system, you have to be paid for that. If you're a non-exempt employee, you have to be paid for that because you cannot volunteer your time. This is another one where a lot of people say, oh, I'll just do it as a favor. I love my job. I'll just come in and do it. Don't worry about paying me. That's an absolute no-no. Okay, you have to be paid for it. There is no volunteering to do your job. So the improper deductions, you can lose your exemption, and it's not just losing your exemption for that employee. If you have exempted, say, and I'm just making it up, librarians, and you make an improper deduction on one librarian, you could lose the exemption for all those librarians. So it's very, very important that you do not make any improper deductions. Say someone was out for 3 hours for a personal reason, and you deduct their salary for that 3 hours, you lose that exemption, and that person must go non-exempt and be paid by the hour. So it's very, very important that you have written in your policies about improper deductions. And for exempt people, you can have banked time and use it, but only in half-day or full-day increments. So if somebody goes to an appointment for 2 hours, you cannot dock that time. Not even out of their banked time. Okay, it's got to be in half-day or full-day increments. And the Family Medical Leave Act, an exception may occur for that, but there's a lot, we're going to go over that in another webinar, but there's very few reasons under the FMLA that you can even dock someone's pay for. So just be very careful of that. There is a safe harbor if you do improperly deduct from someone's pay. The employer has to have a clearly communicated policy prohibiting improper pay deductions. The employee must be immediately reimbursed for that improper deduction, and you make a good faith effort to comply in the future. So basically, if you have a claim brought against you and it was unintentional, it was accidental, you reimburse the employee right away, you have the policy saying you will not make improper deductions, and about your bank's time, and you make the good faith effort to comply in the future, there's typically no penalties will be brought against you. So here's the minimum wage provisions. Right now, as of December 31st, the hourly minimum wage is $11.10 per hour. In the New York City area, this is a little different. So if anyone is from New York City, I have a chart for that as well. But up here in central New York and I call it downstate, the Albany, Mid-Hudson region, it's $11.10 per hour. The cash wage, if you're claiming a tip, I don't think the library systems have any of this, but if you do, it's still $7.50 per hour. And the cash wage plus tip should equal the minimum hourly wage amount. So the basic overtime provisions are, it's a set rate of 1.5 times their regular pay for anything over 40 hours, and it's anything on time worked, not time compensated. This is, again, a little confusing. So if someone works 32 hours, puts in 8 hours of vacation time to reach 40, and then they work Saturday another 8 hours, so they have 48 hours of time on the books, there's no overtime involved because of the 8 hours vacation. Okay, so it's on time worked, not time compensated. And you have to have a set work week, recurring period of 168 hours. So it can be Sunday through Saturday or a Wednesday through Tuesday. For some reason, Cornell chose Thursday through Wednesday. But it has to be set, it has to be written in your policies, and it has to be consistent. So compensatory time, overtime must be paid in cash, okay? The only time that this is different is public sector employees, and I know there are some in the Mid-Hudson library system. They can be granted compensatory time off. So if you put in an extra 4 hours on Saturday that would have put you in overtime, only public sector employees, and you'll know that when you speak to legal counsel, only public sector employees can be granted those 4 hours at another time and not be paid the overtime. And public employees can accumulate comp time. Private sector employees, which most of us are, cannot grant compensatory time, nor can we accumulate comp time. We must be paid the overtime for every hour worked over 40, okay? And it's very important, sometimes people will use a flexible work week, and that's fine, as long as that 4 hours was reduced within the same work week. So if you know you're going to work 4 hours on Saturday that would put you into overtime, maybe on Thursday you leave 4 hours early, but it's within the same work week, and that's really important for private sector employees to know. So here's scenario 1. Your department is going through a budget crisis. You specifically tell your staff no overtime. However, you learn despite your instructions, Lisa's been working through her lunch and time card shows she's worked 45 hours this week. Do you have to pay her overtime? The answer is absolutely. Even though you've instructed them not to work overtime and they do it without approval, you still must pay the overtime, okay? And it sounds it doesn't do much for morale, but you can turn it into a disciplinary action because what she did was disobey a direct order. However, since she worked that overtime by working through her lunch, and she's got that 5 hours of overtime, you still must pay it. A lot of confusion comes in with the FLSA and the Portal to Portal Act, and this defines the beginning and the end of a workday and provides guidelines on travel time, which gets very tricky for non-exempt employees, wait time, on-call, rest meal periods, lectures, the meetings and trainings when you send your employees to training. So for travel time in your ordinary workday, if they travel as part of the principal activity from job site to job site during the workday, they are considered as hours worked. So an employee who travels from home before the regular workday and returns home at the end of the workday is engaged in ordinary home to travel work, and so this is not considered hours worked. A one-day business, when you travel during the one day, time involved in one-day travel, which is over and above ordinary commuting travel, is counted as hours worked. So if you have to if you live in Albany and you have to travel to Poughkeepsie, and you have to be there, say, an hour earlier than normal, that travel time is hours worked. It's over and above your normal time, commute time to get to work. So the travel time would count for you to travel down to Poughkeepsie and to travel home. That's hours worked for a non-exempt staff member. When you're traveling away in an overnight stay, travel away from home is hours worked when it takes place during your employee's regular scheduled hours. So if I have to fly to New York City and my flight doesn't leave till 10 o'clock in the morning, and then I arrive in New York City by noon, that's my regular work day. So I'm paid from that 10 to noon as I'm traveling on the plane. If you travel on a train, bus, airplane, or in an automobile during these hours on a Saturday or Sunday or any other day, that if you have Mondays off, you have to travel on Monday, if you're the driver, it's compensable work time. But if you're a passenger, you do not have to pay that non-exempt staff member. However, if they are a passenger and they discuss anything to do with work, or they're checking their email on their phones or tablets, which we all do, or they do any kind of work on that train, bus, or airplane, even if it's on a Saturday or Sunday or not a regular scheduled work day, they must be compensated. So, although passengers, if you're on the airplane, bus, or train and you're reading a book all the way there, that's not compensable. However, if you pick up your phone and answer an email or a phone call, or you're talking to the driver and you guys are discussing work on your way somewhere, that is all compensable time. So waiting time. There's engaged to be waiting and waiting to be engaged. So if you're engaged to be waiting and the employee cannot use their time for his or own purposes, and it's controlled by the employer and you cannot leave a specific area. So if you're on call and they said, well, you need to be within a 10-minute drive time, you've engaged them to be waiting, and that is compensable. Those people must be paid for that time. If you're just waiting to be engaged and the employee is completely relieved of duties and they can use their time for their own purposes, and they just say, you're on call. If you get a call, get here when you can get here. That is not compensable time. However, once they arrive and start working, that's all compensable. So this one's tricky. As long as you do not restrict where they can travel or limit how fast they have to come in to address the issue, that's not compensable time. But the minute you say, well, if you get a phone call and you need to be here within 10 minutes, all that time becomes compensable. So on-call is hours worked when they have to stay on the premises or they have to stay so close that they can't use their time as their own. On-call is hours not worked when they just have to carry a cell phone. Now, when they pick up the cell phone and they answer that call or that question, that is compensable. So, but the whole time they're waiting for a call will not be if they have the cell phone or they can go wherever they want and their time is not restricted. Rest and meal periods. Any short duration, 20 minutes or less, is usually like a break. So everyone under the Fair Labor Standards Act is given 2 15-minute breaks and I believe a 30-minute lunch. I think it's an hour after 8 or 9 hours. It's an hour. Those 2 15-minute breaks or less than 20 minutes, that's compensable. You don't record your time out for those 2 15-minute breaks. Any unauthorized extension of that could be counted as hours not worked. That's when you could dock the non-exempt employee's pay. Bona fide meal periods, typically 30 minutes or more, need not be compensated as work time. The 30-minute lunch period doesn't kick in until usually you've worked at least 6 hours, but they must be completely removed from duties. So if a receptionist decides I'm going to eat my lunch at my desk and they're checking email or they're still answering the phone, that is all compensable time. They just worked through their lunch and they cannot be docked for their lunch time. So be really careful about that you completely separate them from their duties, either in a lunch break room or they've left the building or something like that. But if they sit at their desk and eat and do any type of work, they now have to be paid for their lunch break. For trainings and seminars, the attendance at any of this, all of the criteria must be met. It's outside of the employee's regular working hours. If it's during their regular work hours, they're paid already. They're there, it's their regular work hours. If it's outside of that, their regular working hours, it has to be voluntary. And this is when the course lecture is not directly related to the employee's job. This is when you don't have to pay them. So it's voluntary that they want to go. It's outside their regular work hours. It's not directly related to what they do, and they do not perform any productive work during their attendance. If you meet all of those criteria, you do not have to pay for trainings and seminars. However, if you meet just one of these criteria where it is directly related to their job or it was not voluntary, all that time spent in the training and seminar, whether it's a regular work day or not, is all compensable time. Excuse me. So again, problems arise when employers fail to recognize and count certain hours as compensable work time. And a lot of that time you run into the working through lunch or going to trainings and seminars or traveling for work. So you just have to remember that any time work is performed during the regular work time is compensable, and any time work is performed outside of regular work hours and is not voluntary or you've really restricted what they can do with their own time, that's all compensable time. So here's another scenario. So an LPN works at an assisted living facility, and they have a sister facility 20 miles away. There have been times that the LPN has been asked to fill in for someone at the other facility after she completes her shift. It takes her 30 minutes to drive to the other facility. The travel time is not recorded on her timesheet. Is this a violation? Yep. because you've asked her to go outside her normal travel time to a sister facility, it must be considered as part of her hours worked. So that 30-minute drive to the other facility must be paid. A residential care facility offers specialized training for Alzheimer residents. There are 2 workshops, one in the evening for the day shift and one during the day for the evening shift. All employees are required to attend. Is this compensable? Yes, because it's not voluntary. You must attend one of them, and it's related to their job. So in April of 2011, New York State came out with the Wage Theft Prevention Act, which was an offshoot of the Fair Labor Standards Act. And it required employee notice of pay in their primary language if it was other than English and at the time of hire. And it had to include very specific things. It had to include their pay, how much they were going to make, their hours worked, the name of their employer, their job title, and, everyday items that should be in an offer letter. If a current employee had any change to their pay, whether it was a deduction or an increase, they must receive the notice of change within 7 days. And it must be signed and dated, written acknowledged in English or their primary language that they received the letter. And failure to comply resulted in penalties. We spoke to our legal counsel, and we were allowed to do this electronically. So if you have an HRIS system that will allow you to do electronic signatures, they did allow that. That was acceptable. It didn't need to be in pen or returned via paper. So, if you're lucky enough to have an electronic HRIS system that can do that, and you just can, you sign in with your employee ID or however you do it and password and hit submit, the Wage Theft Prevention Act said that was sufficient. So under the Wage Theft Prevention, the Commissioner of Labor can keep the name of the employee confidential until disclosure is necessary for resolution. So if a complaint is brought against you, they do not have to reveal who made the complaint until it was time for resolution, which makes it very difficult to defend. They can assess back wages, liquidated damages, no more than 100% of total amount wages, and attorney's fees. So this can get rather expensive for employers. There was a 6-year statute of limitations to file from the start date of the employee's complaint. So this is a lot different than the 3 years that it used to be. It's up to 6. And there was an automatic 15% increase in the award if the back wages were not paid within 90 days. So it's really, really important that if a complaint is brought against you, as hard as they don't have to give you the name until you're ready to resolve the issue, but it's really important that you can resolve something as quickly as possible with back wages, liquidated damages, and pay those within 90 days. And they can go back 6 years. Excuse me. So threats were now included as a form of retaliation. So if you tell someone, well, if you file, you could lose your job, that is considered retaliation on the employee, and it's now counted, and the damages can be higher. It is illegal for any person to retaliate. So it just doesn't have to be the supervisor. It could be a colleague that makes the threat, or a supervisor, a director. So be very careful about that. The DOL, Department of Labor, can order the employer or person who acted against the employee to pay up to $20,000 in liquidated damages. So if you were a colleague and you said, oh, I wouldn't do that, or that, they could fire you, you can now be liable for $20,000 in damages on your own. If the person was let go, the DOL can order you to reinstate that person's job, or in lieu of reinstatement, pay the person for the lost salary, or pay a lump sum back to them for what they lost during that time period. Retaliation does carry criminal penalties. So this is really important that if there's a situation going on, you ask all employees, supervisors, managers, directors, you are not to discuss this at all. If they do retaliate or something that is could be deemed retaliation, they could be arrested. There's criminal penalties. There's the $20,000 in liquidated damages. So it's very hard to prove that it was not retaliation, and all of the burden would be on the employer. The PAIDS program. So this is new that came out of the Federal Department of Labor. What they're trying to do is resolve any of these complaints for overtime before it really gets down the road where the DOL will come in and audit you and do a full-blown audit. They wanted these ones where the complaints, it was just an honest, unintentional mistake. They're trying to facilitate resolution before there's a full-scale audit done, okay? They want to do it expeditiously. They don't want to take this to litigation, and they want to help employers really improve their compliance and use these more as like teaching moments, so to speak. So you can go on, they have a website, and I'll show it to you, where you can log in, the employer can go in and take all the steps necessary so that this does not go to litigation or an audit. What it will do is they have to specifically identify the potential violation, and this is self-reported by the employer, which is really nice. We made a mistake, we're going to self-report, and you have to identify which employees were affected, the time frames, give them the calculate all the back wages that they believe are owed to employee. So you would put this all in the system. You contact the wage and hour division to discuss the issues and what your potential resolution would be. And so here's everything that you would have to submit, that you're required to submit to start this, to stop it from going to litigation or an audit. You know, the back wage calculations with supporting evidence and your methodology for doing that. A concise explanation of the scope of the potential violations, certification that the employer reviewed all of the program's information, terms, and compliance. It's a pretty long document, but that you reviewed that, and so you know what it entails, and a certification that the employer meets all the eligibility criteria of the program. So this is the, excuse me, the website, dol.gov, WHD, which is the Work and Hour Division, the Wage and Hour Division, and it's the PAIDS program. So we went through that pretty fast in 40 minutes. I'm going to turn it over to questions. I'll turn it back to Casey for questions, and we'll start from there.
Thanks very much, Sherry. That was good. So we did have a couple questions that came in. We had specifically somebody asked, in terms of improper deductions and deductions. So we had a question, can someone use 1 hour of paid time off to go to the doctor? I know you were saying that, you know, it has to be half day or whole day increments. Can you answer that question?
Only if you're hourly. So if you're paid by the hour, yes, you can. If you're paid by, if you are salaried, no. So
right.
Not for 1 hour. So if they have an appointment for 1 hour, they just go. It can be considered a lunch or something, and they just go. Now, if they're gone for a half a day, that's typically 3 or 4 more hours, depending on what your work day is, then yes, you can take that out of your banked time, whether it's sick, personal. Some people have just one banked time, PTO time, and it can, you know, and it handles your sick, personal, and vacation all at once.
Okay.
But no, as an exempt employee, you cannot be docked for just 1 hour, not even out of your bank's time.
Okay. Anybody else has any questions, you can put them in the chat box to everybody. You can send them just to me if you like. All right, we did have another question about comp time and compensatory time. And it was, who decides if an employee's, I guess, extra hours would be considered work time, comp time or overtime? Would it be the administration, or does the employee have a say in that?
No. So, excuse me. Comp time, if you are a public sector employer, and I know there are some on the phone, it is at the discretion of, if you have HR, or of your director, supervisor, manager, whichever level you have. You can talk to the employee about the comp time, knowing they have to work an extra 4 hours on Saturday. It's an agreement how you're going to do that, whether you're going to bank it, which you can as a public sector employee, or, comp it like the following week or something. As a private and sector employee, you have no choice. So if you've asked an employee to come in for the 4 hours on a Saturday, and there's no way to give them 4 hours off on another day during that week, so they stick to the 40, that's overtime eligible. It's overtime paid. Does that answer the question?
I think so. Whoever submitted that question, if you need more information, you can let us know. We can ask more or clarify it.
If you're a private sector employee, no, it has to be paid overtime or within that same work week. So if your work week is Sunday to Saturday and you need them to work the 4 hours on a Saturday and you don't want them to get overtime, then you can tell them on Tuesday, don't, come in for less hours. And that's, you can talk to the employee about that. But if you need them there a week plus the 4 hours on Saturday, that is to be overtime paid, time and a half.
Okay, all right. We had another question. If someone were running late one morning and they got to work an hour late, can they use an hour of their paid time off if they're a salaried employee, or are they using a half day again?
No, still a half day. If they're just running an hour late and they're salaried, they're running an hour late. Chances are, they'll make up the hour somewhere else. But as an exempt employee, no. I mean, they're just running an hour late.
Okay.
Now, if it's a consistent practice, I will say this: if it's a consistent practice, no, you still cannot dock from their time, but it is a disciplinary action.
Could you have something in place for employees? Could you have sort of be practice, like you said, that if you come an hour late, maybe you can work an extra hour? Is that an acceptable kind of thing?
Sure. Yeah, absolutely. Yep.
Okay.
That's more of a flexible work time, so that's fine. But what you can't do is take an hour of an exempt employee's bank's time, because you don't really work in hours as an exempt employee. Typically they say if you're exempt, you work at least 45 hours a week, right? So 45 or more. So you're not allowed to bank just by the hour. It'd have to be in half day or full day increments. So.
Okay. Another question. So along the same topic, if there was a union contract in place and the teacher's contract allows them to take quarter days off, would they be able to take a different kind of increment of day off than half or full day as you're describing?
Yeah, so union contracts are a little bit different. Teachers are a little bit different because they actually have no minimum salary requirements to meet, and you have to be a bona fide teacher. So in an elementary, secondary education, elementary schools, middle schools, high school, the collegiate level. So union contracts, if that's what's stated in the union contract, then yes, that's okay. But they would still have to take it out of banked time. They wouldn't be allowed to dock their pay.
Okay, and a teacher's contract would only cover teachers? Is that in the law somewhere that only teachers can do certain things? I know there's different rules for policemen and stuff too.
Yeah, a lot of this is teachers are very specific under the FLSA. First responders, which police officers are, including sergeants. It's very specific under the FLSA that they are all non-exempt and are entitled to overtime pay. Typically, and in a police union, they can't even, although they're public sector employers, they don't even allow comp banked time. Typically, most of the time is overtime eligible, and they're paid the overtime. And it's very specific in the FLSA on that. So, okay. Yeah, union contracts. They're difficult against the FLSA. They do have to follow it, but with teachers, the rules are slightly different. And because of their work schedule, if they say they're allowed to take quarter time increments out of their banked time, I believe they're allowed to do that.
Okay. We have another question. Is comp time allowed for exempt public sector employees, or is it considered flex time? Are those?
I believe it can be both. So it is considered flex time. So if you really put in, say you typically work 50 hours a week and you had to put in, say, 60, 65 hours one week, as an exempt employee, they say, it's not about the hours worked, it's about getting the job done. However, if you have an agreement with your employer saying, I really did put in that extra 15 hours, could I take a day or, flex my schedule the next week? Yes, you can do that.
Okay. And if anybody needs to follow up on any of these answers, and just drop it in the chat box, of course.
Okay. And I'm going to send Rebecca, it's the Department of Labor wage and hour fact sheets of each of these exemptions that give it in a little bit more detail. And I'll give you the wage theft prevention fact sheet, and I'll put in as much information as there, so you guys have it right at your hands, and you can print them off or keep them in electronic files, so that if you ever have to refer back to them, you'll have them.
Okay, great. Thank you.
Mm-hmm.
Are there any other questions anybody has for Sherry? I'll give it another minute or two to see if anybody is typing right now. I don't want to cut anybody off. All right, if that's it, I'm going to say thank you very much, Sherry. We appreciate you coming and presenting to us, and we look forward to the next two presentations. And thank you to everybody who came. If you do think of questions after we get off the webinar here and you want to ask them, then you can feel free to send them to me at cconlin@midhudson.org, or you can call me. Again, thanks very much, everybody, for coming. And I guess we'll call it a day. Thank you.
Okay, thank you.